Have you ever considered how the most fundamental things in our lives, those pillars we rely on, still manage to evolve? Think about a city's infrastructure, designed to last for centuries, yet it constantly needs updates. New roads, smarter grids, adapting to growth, or even something as seemingly fixed as a cherished family recipe. It might be passed down through generations, but subtly adapts over time, maybe a pinch more of this, a dash less of that, responding to new tastes or ingredients. How do you keep something foundational while allowing it the flexibility to grow without fundamentally breaking it? It's a fascinating challenge, isn't it? Well, today we're taking a deep dive into an even grander and more profound example of this very idea, the Indian Constitution. This isn't just a document, it's the foundational legal blueprint for the world's largest democracy, a living guide for over a billion people. And yet, it's meticulously designed to adapt, to breathe, to evolve with the nation it governs. Our mission today is to unpack the intricate procedures involved in changing this colossal document. We'll uncover why it's been lauded by constitutional scholars as a masterpiece of balance, neither too easy nor too difficult to amend. And crucially, we'll understand what this unique amendment process truly means for the future of India and for you as its citizen. We've distilled the most important nuggets of knowledge from the sources you've provided, offering you a shortcut to being genuinely well-informed on this absolutely crucial aspect of Indian polity. We'll explore the president's rather unique and specific role, discover how certain parts of this document are treated more like adaptable software, allowing for swift updates, while others are guarded with the utmost care, much like a nation's core principles. Get ready to explore the foundational rules of a vibrant, dynamic democracy. Okay, let's unpack this right from the top. Why does any constitution, especially one designed to be the supreme law of the land, even need to be amended? Isn't the whole idea for it to be permanent and unwavering, sort of like a rock in a changing world?
That's a really perceptive question because, yeah, on the surface, permanence seems like the goal. But the reality is that societies are incredibly dynamic. They just don't stand still. Think about how much India has changed since its constitution was adopted back in 1950. Technological leaps, huge shifts in social norms, new economic challenges, unexpected global events. If a constitution is too rigid, if it can't adapt to these profound shifts, it risks becoming, well, obsolete. It can actually stifle progress rather than guiding it. It essentially stops being what we call a living document.
A living document, right. It needs to breathe with the times.
Exactly. Our sources beautifully articulate this need for flexibility. They quote Pandit Jawaharlal Nehru, one of India's founding fathers, from the Constituent Assembly debates. He said, and it's quite profound, while we want this constitution to be as solid and permanent as we can make it, there is no permanence in a constitution. There should be a certain flexibility. If you make any constitution rigid and permanent, you stop the nation's growth, the growth of a living, vital, organic people. That really captures the core dilemma, How do you find that sweet spot between providing that solid stability and allowing for essential flexibility?
And it sounds like India, according to our sources, has managed to strike a truly unique solution to this problem. They describe its constitution as neither as easy as in Britain nor as difficult as in USA, which, that's quite a claim.
It is, and it's actually very accurate. To really get what this synthesis means, maybe let's quickly contrast it with those two examples you mentioned.
Okay.
So one end, you've got Britain's constitution. It's largely unwritten, famously flexible. Their parliament can basically change constitutional law with a simple majority vote, just like any other law.
Wow, okay. Super flexible then.
Extremely. Which allows for rapid adaptation. Sure, that can be good. But arguably, it offers less solid protection against, say, sudden drastic shifts in power or rights.
Right. It could be changed too easily, perhaps.
Potentially. Then, on the other end of the spectrum, you have the United States Constitution, famously rigid, amending it. It requires supermajorities in both houses of Congress, 2/3, specifically and then critically, ratification by 3/4 of the individual state legislatures.
3/4 of the states. That sounds incredibly difficult.
It is. It's extraordinarily difficult. It forces this incredibly broad consensus, which is definitely a strength in terms of stability, but it can also make the system quite slow to respond to new challenges. Sometimes it leads to feeling kind of stuck in outdated ways of doing things.
So facing those two extremes.
Exactly. India's framers consciously looked at these models and others and deliberately chose a middle path. They really understood the need for both stability and adaptability. They were aiming to create a framework that could grow and evolve with the nation without being subject to just, transient political majorities or conversely getting locked into provisions that maybe no longer served a rapidly changing society.
Okay, so India finds this middle ground, this synthesis. How does it actually work? Where are the nuts and bolts, the specific rules for making these fundamental changes?
That's where Article 368 comes in. It's right there in Part XX of the Constitution. Think of it as the central pillar for constitutional amendments. This article clearly states that Parliament, using its constituent power, can amend by way of addition, variation, or repeal any provision of the Constitution.
Okay, so add, change, or remove. That sounds pretty comprehensive.
It is. It's a broad grant of power,
Yeah.
reflecting, the ultimate sovereignty of the people's representatives. But, and this is where it gets really fascinating, a crucial point our sources highlight, there's a critical caveat that comes right after this broad power. Despite Parliament's expansive constituent power, it cannot amend those provisions which form the basic structure of the Constitution.
The basic structure, right? This isn't actually written in the Constitution itself, is it? This came from the court.
Exactly. It's a judicial innovation, a really powerful one, born from that landmark Supreme Court case, Kesavanath-Haradi, back in 1973.
Okay, tell us about that case. What led to this basic structure idea?
Well, before this judgment, there was a huge debate going on. Was Parliament's power to amend the Constitution truly absolute? Could it change anything, even fundamental rights? Or the things that define India as, say, a democratic republic? Parliament had, in some earlier instances, tried to assert that it had unlimited power to amend, which led to legal challenges.
Understandable.
So the Supreme Court, in that pivotal 73 ruling, gave this really nuanced and far-reaching verdict. It said, yes, Parliament has the power to amend the Constitution. However, that power is not unlimited. It cannot be used to alter or destroy what the court called the basic structure or the fundamental framework of the Constitution.
Right, so like the essential core.
Precisely.
Okay.
The court didn't give like an exhaustive checklist of what's in the basic structure, but it pointed to certain essential features. Think of it like this. If the Constitution is a building, Parliament can renovate rooms, repaint walls, maybe even add an extension.
Right.
But the basic structure is like the foundation, the main load-bearing walls, the core design that makes it that specific building. You can't tamper with those without essentially destroying the building itself.
That's a great analogy. So what kinds of things are considered part of this basic structure?
Well, over time, through other judgments, things like the supremacy of the Constitution itself, the Republican and Democratic form of government, India's secular character, the separation of powers between the executive, legislature, and judiciary, federalism, the independence of the judiciary, and fundamental rights. These have generally been seen as part of this core structure.
Wow. That's a truly crucial aha moment then, because it introduces this unique check, right? A judicial check on the power of the elected parliament. What does that really mean for how Indian democracy works?
It means that while the Constitution is definitely designed to be a living, breathing document, it has this inviolable core, a set of fundamental principles that define India's identity. The implications are huge. It basically elevates the judiciary beyond just interpreting laws. They become active guardians of the Constitution's essence, its soul, you could say.
Like our guardian rule.
Yes. It puts a fundamental limit on Parliament's amending power. It ensures that while the Constitution can evolve, its foundational principles stay intact. It sets up this constant vital dialogue between the legislature and the judiciary, making sure any amendment fits the spirit, not just the letter, of the original document.
So it protects the core values regardless of who's in power.
Exactly. It prevents any temporary majority from fundamentally changing the nation's character as, a democratic, republican, secular federal nation committed to individual rights. It's a powerful safeguard.
Okay, so now we understand the why, the need for it to be a living document, and this foundational basic structure principle that acts as a guardrail. Let's get into the how. What are the specific steps laid down in Article 368 for actually doing an amendment? This is where that synthesis of flexibility and rigidity must really show itself, right? It can't be just one simple process.
Absolutely. Article 368 outlines a clear, multi-step procedure. Think of it like a series of checkpoints Parliament has to pass through. Okay, first let's talk about initiation, getting the process started. An amendment to the Constitution can only be initiated by introducing a bill specifically for that purpose in either House of Parliament, so the Lok Sabha or the Rajya Sabha.
Only Parliament, so states can't kick off an amendment.
Correct. That's a key distinction. State legislatures cannot introduce a constitutional amendment bill, which is different from how it works in some other federal systems. It's a central legislative process right from the beginning.
Got it. And who can introduce this bill in Parliament?
What's interesting here is its accessibility. The bill can be brought in either by a minister that's pretty standard for government business, or, quite significantly, by a private member.
A private member. So any individual MP,
Right.
theoretically.
Yep, and an MP who isn't part of the government, not a minister. And importantly, this bill does not need prior permission from the president before it's introduced.
No presidential gatekeeping at the start.
Right. It really emphasizes the democratic nature of it. Even an individual MP, if they can gather enough support, can propose fundamental changes to the nation's highest law. The initiative truly lies with Parliament.
Okay, so the bill is introduced. What happens next? Passage.
Exactly. Next up is passage in Parliament. And this is where that special majority requirement kicks in, making it much tougher than passing an ordinary law. The bill has to be passed in each house separately by this special majority. It's not just a simple majority of who's there and voting. It's what I sometimes call a double lock system.
Okay, break down the special majority for us. What does that actually involve?
Right, so it requires two conditions to be met at the same time. First, you need a majority of the total membership of the House.
Total membership, meaning more than half the entire number of seats in that house?
Precisely. More than 50% of the authorized strength. It doesn't matter if there are vacancies or if members are absent on voting day. So say the Lok Sabha has 543 members. You need at least 272 votes, even if only, say, 300 members actually show up for the vote.
Okay, that's condition one. And the second part.
The second condition is that you also need a majority of 2/3 of the members of that House who are present and voting. So in our example, if 300 members are present and voting, you'd need at least 200 of their votes, 2/3 of 300. And that number, 200, must also be greater than half the total membership, which was 272. So in this case, 200 isn't enough. You'd need at least 272 votes from those 300 present.
Wow. Okay, so you need a high percentage of those voting, and that number has to represent a majority of the whole House. That's a really high bar.
It absolutely is, and it's a very deliberate design choice.
What's the practical impact of setting the bar so high?
Well, the impact is huge. It ensures really broad consensus. It prevents hasty or purely politically motivated changes to the fundamental law. A ruling party, even one with a comfortable, simple majority, usually can't push through constitutional amendments on its own. They need significant support from across the political aisle, or at least a very substantial chunk of it.
So it forces negotiation, compromise.
Exactly. It forces a real effort to build cross-party agreement. It ensures that these fundamental changes are more likely to reflect a widely accepted national evolution, rather than just the preference of whoever's in power at that moment. And our sources also clarify something interesting. Strictly speaking, the special majority is required only for voting at the third reading stage of the bill.
Ah, the final vote.
Yes, but by way of abundant caution, the requirement for special majority has been provided for in the rules of the Houses in respect of all the effective stages of the bill. So, in practice, that high bar applies throughout the bill's journey in Parliament.
Good to know. Okay, what's next after the special majority?
Next, we need to talk about separate passage and no joint sitting. Each House, the Lok Sabha and the Rajya Sabha, must pass the bill separately with that special majority.
Separately. Okay. What if they disagree? Like one house passes it and the other doesn't, or they want different versions?
That's a crucial point.
Yeah.
Unlike with ordinary bills, if there's a disagreement or a deadlock between the two houses on a constitutional amendment bill, there is no provision for holding a joint sitting of the two houses to resolve it.
No joint sitting. But they do that for regular laws, right? Why not for constitutional amendments? That seems significant.
It is hugely significant. It really signals that amending the Constitution is in a totally different category of lawmaking. For ordinary bills, a joint sitting usually allows the Lok Sabha, which has more members, to potentially prevail in a deadlock because of its numbers. But for constitutional amendments, the absence of a joint sitting means both houses, the Lok Sabha representing the people directly and the Rajya Sabha representing the states, must independently agree to the changes with that demanding special majority. It forces much greater agreement. It prevents one house from just steamrolling the other on fundamental law. It underscores the gravity such a profound change needs serious independent consensus from both chambers.
Okay, that makes sense. It adds another layer of protection. Now, you mentioned the Rajya Sabha represents the states. Does that lead to the next point about states having a role?
It does, perfectly. That brings us to the role of states for federal provisions. If the amendment bill seeks to change certain provisions that directly impact the federal structure of the Constitution, basically, the balance of power between the union government in Delhi and the state governments, then there's a third hurdle. The bill must also be ratified, meaning approved, by the legislatures of at least half of the states. and they only need to pass it by a simple majority in their respective legislatures.
Okay, so not all states, just half. And by a simple majority there, what exactly counts as these federal provisions that need this extra step? Why is state approval so vital for these specific changes?
You've hit the nail on the head.
Hmm.
Federal provisions are those that inherently involve the states, or that delicate power balance between the center and the states. Think about things like the election of the president. The president is head of the whole federal state, and the election involves state legislatures, so changing that needs state buy-in.
Makes sense.
Or the extent of executive power of both the union and the states, defining how far their authority reaches. That's core federal stuff. Changes to the Supreme Court and high courts are also included, as they're the judicial pillars across the whole federal system.
Right.
And absolutely critical, the distribution of legislative powers between the union and the states. This is the heart of federalism, who gets to make laws about what subjects, as laid out in the 7th schedule of the Constitution. Any change to that fundamental division needs state consent.
So it protects the state's areas of authority.
Precisely. It's a vital check, ensuring the central government can't just unilaterally rewrite the relationship it has with the states. It protects that federal character. And our sources point out a couple of interesting details here. First, if one or some or all the remaining states take no action on the bill, it does not matter. The moment half of the states give their consent, the formality is completed.
So you just need to hit that 50% mark. The rest don't have to act.
Correct. Just need half the states on board. And second, there's no time limit within which the states should give their consent to the bill.
No deadline for the states. That seems flexible, but maybe could lead to delays.
It does offer flexibility, yes, but it can sometimes mean amendments needing state ratification take quite a while to actually get finalized as states deliberate on their own timelines.
Okay, so Parliament passes it with special majority, both houses separately, and if it's a federal provision, half the states ratify it. What's the final step? The president.
Exactly. The final step is presidential assent. After the bill has successfully navigated Parliament, and the states, if required, it's presented to the president for their assent, their signature. And here's another crucial difference compared to ordinary laws. The president must give his or her assent to the bill.
Must. So no choice.
No choice. He or she can neither withhold his or her assent to the bill, nor return the bill for reconsideration to the Parliament.
Wow. That's fascinating. For a normal bill, the president can say no or send it back with suggestions, right? But not here. It sounds almost ceremonial for amendments.
You've absolutely nailed the distinction. With ordinary laws, the president acts as a potential check, using their veto power or asking Parliament to rethink. But for a constitutional amendment bill, their role is indeed purely formal. They're obligated to sign it. This obligation was actually cemented by the 24th Constitutional Amendment Act back in 1971, which explicitly removed any ambiguity.
So once Parliament and the states, if needed, have done their part, it's a done deal. The president just makes it official.
Pretty much. It signifies that the ultimate constituent power, the power to change the fundamental law, rests with the legislative bodies, Parliament and the states, once they've followed the rigorous procedures. It removes any potential final veto by the executive branch on these fundamental changes. It underscores the supremacy of the democratic process in amending the Constitution. Once the president gives assent, the bill becomes an act, a constitutional amendment act, and the Constitution officially stands amended.
Okay, so putting it all together, it seems like there's more than just one single pathway to amend the Constitution. It's not a one-size-fits-all process. Our sources talk about 3 distinct ways, each with a different level of difficulty. Let's really dig into those now. Why different paths?
That's exactly right. It's not monolithic. While Article 368 itself describes 2 main methods, the special majority one and the special majority plus states one, there's actually a third category we need to consider first. Certain provisions in the Constitution can be amended simply by a simple majority of a parliament, just like passing an ordinary law. And this is really key. The sources emphasize that these amendments made by simple majority are not considered amendments of the Constitution for the purposes of Article 368 itself. They're treated differently.
Ah, okay, so they don't even fall under the main amendment article.
Correct. So effectively, we can group the amendment processes into these 3 paths. Path 1, amendment by simple majority of Parliament. This is outside Article 368. Path 2, amendment by special majority of Parliament. This is the main one under Article 368. Path 3, amendment by special majority of Parliament plus ratification by half the states, also under Article 368 for federal issues. Each path is basically tailored to the kind of constitutional provision being changed.
Let's start with path 1 then. Amendment by simple majority. You said these are outside Article 368, treated like ordinary laws. What kind of changes are considered less fundamental, I guess, that they don't need all the Article 368 heavy lifting?
Think of these as the Constitution's more operational or administrative elements. They're important, absolutely, but they relate more to the day-to-day functioning or organization of the state rather than its core principles or fundamental structure. Because they're more procedural, the Constitution allows them to be changed more easily, with just a simple majority in each house that's just more than 50% of those present and voting. It allows for necessary administrative agility.
Okay, like what specifically? Can you give some examples?
Sure. A big one is how India manages its internal map, essentially. The admission or establishment of new states, or the formation of new states, and alteration of areas, boundaries, or names of existing states.
Right, like when new states are created or boundaries are adjusted, that happens.
Exactly. That process happens through this simpler path. Another key example is the abolition or creation of legislative councils in states. Some Indian states have 2 houses, some have 1. Changing that structure is done this way. And this one's unique because, as we touched on, it's the only case where a state legislature can technically initiate the process by passing a resolution, though Parliament still has the final vote.
Interesting. What else falls under this simple majority category?
Well, there's quite a list in the sources. Things like changes to the second schedule, which deals with salaries, allowances, privileges of high officials, the president, governors, speakers, judges, etc., adjusting their pay, for example.
Practical stuff.
Right. Also, practical rules for how Parliament works, like the quorum need for sessions or salaries and allowances for MPs. Rules concerning citizenship acquisition and termination, how union territories are administered, rules regarding elections to Parliament and state legislatures, use of the official language, the list goes on.
So basically, lots of important operational details, but not the core rights or structures.
That's a good way to put it. They allow the system to adapt efficiently without triggering the much higher thresholds needed for more fundamental changes.
Okay, that makes sense. Now let's move to path 2, amendment by special majority of Parliament. This seems like the main engine of amendment under Article 368, covering most of the Constitution. Remind us again quickly about that special majority definition.
Right, this is the big one. The special majority, just to recap, is that double lock. First, a majority of the total membership of each house, and second, a majority of 2/3 of the members of that house present and voting. Both conditions must be met in each house, separately.
Got it. Total membership plus 2/3 PNV. So what crucial parts of the Constitution are protected by this higher standard?
This path covers some of the most fundamental and significant elements. Most notably, it applies to the fundamental rights, the core civil liberties guaranteed to citizens, and the directive principles of state policy, which guide the state in working toward social and economic justice.
Ah, okay. Fundamental rights and directive principles. If you connect that to the bigger picture, it's really clear why changing those would require such a strong consensus, right? You wouldn't want basic rights or national goals to be altered lightly.
Absolutely. It underlines how deeply protected these aspects are. It prevents a simple parliamentary majority from easily eroding individual freedoms or changing the fundamental socioeconomic direction of the nation. It forces a much broader agreement.
And what else besides rights and principles?
This category also acts as the default, you could say. The sources state it covers all other provisions which are not covered by the first and third categories. So basically, if a constitutional provision doesn't fall into the simple majority bucket, path 1, or the special majority plus states bucket, path 3, then it needs this special majority path 2 to be amended. This makes it the most common method used for significant constitutional changes under Article 368.
Okay, clear. Now for the third and most rigorous path. Amendment by special majority of Parliament and consent of states. This adds that extra federal layer. What provisions are considered so vital to the union-state balance that they need this highest level of approval?
These are the provisions that, as the sources clearly state, are related to the federal structure of the polity. They touch upon the very core of how power is shared and how the different levels of government interact in India. Because these changes directly affect the state's powers, rights, or the relationship with the center, it's essential they have a direct say. It's the ultimate safeguard for federalism in the amendment process.
So what are the key examples here?
Well, we already touched on some when discussing state ratification. The election of the president and its manner is one. The extent of the executive power of the union and the states defining their operational boundaries. Changes affecting the Supreme Court and high courts.
The pillars of the federal judiciary.
Exactly. And critically, the distribution of legislative powers between the Union and the states. This includes any of the lists in the 7th schedule. The Union list, state list, concurrent list, which spell out who can make laws on which subjects. Altering that fundamental division requires state consent.
That seems absolutely central to federalism.
It really is. Another example is the representation of states in Parliament itself, how many seats each state gets, etc. That directly impacts their voice at the center. And our sources highlight a specific, more recent example, the Goods and Services Tax Council. They note, this provision was added by the 101st Amendment Act of 2016, related to Article 279A. This shows the system adapting to major economic reforms that fundamentally change the fiscal relationship between the center and states, requiring their buy-in.
That's a great real-world example of this path in action.
And perhaps the most meta, but incredibly important one. The power of Parliament to amend the Constitution and its procedure, Article 368 itself, also requires this Path 3 approval, special majority plus state ratification.
Wow, really? So changing the rules of amendment requires the toughest amendment procedure.
Exactly. It's a brilliant piece of constitutional design. It means the central parliament can't just unilaterally make it easier for itself to amend the Constitution or reduce the state's role in the process without getting the consent of half the states. It locks in the amending procedure itself, protecting the federal balance right at the source code level, so to speak.
That is fascinating. It really shows the depth of thought that went into protecting the federal structure. Okay, so we've mapped out these 3 distinct paths, the different layers of protection. It's clearly a diverse system, as Granville Austin called it. But as we know, no system is without its critics. What are some of the common criticisms or potential weaknesses people point out about India's amendment procedure?
That's a really important part of the picture, understanding the critiques. Despite being widely praised for its balance, the Indian process isn't immune to criticism. Several points come up repeatedly. One major one is the lack of a dedicated special amending body. Unlike the U.S., which theoretically could have a constitutional convention just for amendments, India doesn't have that. The power to amend rests primarily with the regular parliament.
So critics worry Parliament might treat it too much like ordinary lawmaking.
That's the concern, yeah. That the line between Parliament's day-to-day legislative job and its more profound role as a constitution amending body gets blurred. Does it give constitutional change the distinct gravity it deserves? Another point is Parliament's near-exclusive power to initiate amendments. As we discussed, the power to kickstart an amendment almost entirely lies with Parliament. State legislatures can't really propose amendments, except for that one narrow case about their own legislative councils.
Right, unlike the U.S., where states can trigger the process.
Exactly. Critics argue this concentrates too much initiative power at the center and limits the state's ability to drive constitutional change from their perspective.
Okay, what else?
Well, related to that is Parliament's generally dominant role compared to some other federations. A large chunk of the Constitution can be changed by Parliament alone, needing only that special majority. State consent is needed only for specific federal provisions, and even then, just half the states suffice.
Compared to the U.S. needing 3/4 of the states.
Right. The U.S. system gives states significantly more collective veto power over amendments. So some argue India's system, while federal, leans more toward central dominance in constitutional matters. It definitely raises questions about that center-state power balance in the context of amendments.
Are there issues with the state ratification process itself?
There are some practical ambiguity. The Constitution doesn't set a time limit for states to approve or reject an amendment sent to them.
We mentioned that earlier, so it could theoretically drag on indefinitely.
It could, potentially leading to long delays and uncertainty. Also, the Constitution is silent on whether a state, after approving an amendment, can later withdraw its approval. Say if a different government comes to power in that state, that lack of clarity could create complications.
I see. What about the parliamentary stage?
The absence of a joint sitting mechanism for deadlocks between the Lok Sabha and Rajya Sabha on amendment bills is sometimes criticized.
We saw that as a way to force consensus, but the flip side is?
The flip side is that it can lead to stalemate. A single house, perhaps the Rajya Sabha, where the ruling party might lack a special majority, could potentially block an amendment that otherwise has broad support, maybe even from the directly elected Lok Sabha in many states. Critics argue this could lead to legislative gridlock on important constitutional issues. Another point often raised is the similarity of the amendment process to the ordinary legislative process. Barring the special majority rule, the stages a constitutional amendment bill goes through in Parliament look very much like those for a regular law.
And the concern there is perception, that it doesn't feel special enough.
Kind of. Does this procedural similarity perhaps reduce the perceived sanctity or gravity of amending the Constitution? Does it make it feel less like altering fundamental law and more like just another piece of government business? That's the question some raise. And finally, some argue the constitutional provisions detailing the amendment procedure itself are a bit too brief or sketchy.
Sketchy, meaning not detailed enough.
Yes, that they leave room for interpretation. And this, critics argue, inevitably leads to a wider scope for judicial intervention. Matters end up in court for judges to interpret the ambiguities. This loops back to the basic structure doctrine, the judiciary stepping in to fill gaps or define limits not explicitly spelled out in the text. It suggests maybe the framers left certain aspects intentionally open-ended for judicial evolution.
Those are definitely some significant points to consider. It adds important nuance. But despite these criticisms, the sources clearly argue strongly in favor of the Indian system overall. What makes it so admired? What's the powerful counter-argument?
Well, absolutely. Despite acknowledging these potential drawbacks or areas for debate, the overwhelming view highlighted in our sources is that the process has actually worked remarkably well for India. One of the strongest justifications is simply its proven effectiveness in practice. The sources describe it as having proved simple and easy in its actual operation over 70-plus years. And crucially, it has succeeded in meeting the changed needs and conditions of a vast, complex, and rapidly evolving nation. That's a powerful, pragmatic defense it works.
So the results speak for themselves, essentially.
To a large extent, yes. And the core reason it works, according to its defenders, is that carefully engineered, balanced approach. The procedure is deliberately not so flexible as to allow the ruling parties to change it according to their whims. That directly counters the fear of legislative dominance. It requires more than just a fleeting majority.
Right.
But at the same time, nor is it so rigid as to be incapable of adapting itself to the changing needs. This avoids the paralysis you might see in systems that are too hard to change. It hits that middle ground.
The synthesis we talked about at the start.
Exactly. And this balance has been praised by many scholars. K.C. Ware, a very respected name in constitutional studies, famously said it strikes a good balance between flexibility and rigidity. And you can see why that balance is so vital for a country like India. Huge, diverse, developing fast. It needs a foundational law that provides stability, but can also adapt without breaking or becoming irrelevant.
It connects back to what Nehru said too, right? About not stopping the nation's growth.
Precisely. Revisiting Pandit Nehru's words from the Constituent Assembly really captures the philosophy. While we want this constitution to be as solid and permanent as we can make it, there is no permanence in a constitution. There should be a certain flexibility. If you make any constitution rigid and permanent, you stop the nation's growth. That vision of adaptability as essential for national life is embedded in the process.
And Dr. Ambedkar, the architect of the Constitution, what was his take?
Dr. B.R. Ambedkar also spoke very clearly on this in the Assembly. He noted that India deliberately avoided extremes. It didn't make amendment impossible, like in Canada at the time, nor did it make it subject to extraordinary terms and conditions, like in America or Australia. Instead, he said, India has provided for a facile procedure for amending the Constitution. And facile here doesn't mean simplistic or careless. It means appropriately achievable, readily managed. He saw it as a pragmatic, workable system designed to be responsive.
So facile as in doable when necessary.
Exactly. Doable, but not too easy for the really important stuff. K.C. Ware also admired the amendment methods, the three paths we discussed. He called this variety wise but rarely found, highlighting the sophisticated design.
Tailoring the difficulty to the subject matter.
Precisely. And Granville Austin, another major scholar of the Indian Constitution, summed it up beautifully. He said, the amending process has proved itself one of the most ably conceived aspects of the Constitution. Although it appears complicated, it is merely diverse.
Merely diverse. I like that.
Right.
Not complex just to be complex, but diverse because it needs to be, to handle different kinds of change appropriately.
That's a perfect way to understand it. The diversity is its strength, reflecting the complex reality of governing India.
So, reflecting on everything we've covered, what does this all mean for us, the listeners, as we think about India's path forward? We've really gone deep into this intricate world of constitutional amendments. It's clear it's not a static document set in stone, nor is it something easily tossed around. It's this carefully calibrated system reflecting India's commitment to both lasting principles and the absolute necessity of evolution. We've covered a lot from the basic structure doctrine acting as that fundamental safeguard, ensuring the core identity remains, through the three distinct paths for amendment, each with its own threshold, and we've weighed the criticisms against the praised strengths of this unique system. You should now have a much richer understanding of this vital process. This has really been, we hope, a shortcut to being well informed, giving you not just the what and how, but the crucial why, the context, the implications, the whole philosophy behind it that brings these procedures to life. You now have a better grasp of this unique feature of Indian democracy. So here's a final thought to leave you with. As India keeps growing, evolving, facing brand new challenges, think about AI, climate change, maybe new social dynamics, the digital world, how might this ably conceived yet merely diverse amendment process continue to shape its journey? What kinds of emerging issues do you think might test the limits of its flexibility or perhaps bump up against the rigidity of that basic structure doctrine in the decades ahead? How might that ongoing conversation between Parliament and the courts evolve? Something to definitely mull over. Thank you so much for joining us on this deep dive. We really hope it sparked your curiosity and deepened your understanding of the Indian Constitution's remarkable ability to adapt. We look forward to exploring more with you next time.